Usually when we talk about property ownership in this country, there is this underlying expectation of absolute permanence.
Oh, totally. The whole American dream thing.
Right, exactly. You pay off your mortgage, you get that physical piece of paper, the deed, in your hands, and there's a profound sense of security. You think, this is mine.
Yeah, short of a meteor striking the Earth, right?
Yeah, nothing can take it away. It's a very binary, comforting concept. You either own it free and clear or you just don't. We build our entire concept of generational wealth around that.
We really do. We like the boundaries to be absolute.
We do. But then, you know, you step into the incredibly murky bureaucratic machinery of local property taxes.
Oh, boy. Yeah.
And suddenly that comforting sense of permanence just like evaporates. I mean, imagine for a second that you, the listener, are holding that paid off deed to a beautiful family estate.
Something that's been in the family for years.
Right. And then you lose it completely. Not because of a natural disaster, not because you went bankrupt, but over a disputed $2,200 administrative error.
A rounding error, really, in the grand scheme of the property's value.
Exactly.
It sounds like a dystopian novel, honestly, but it is the absolute definition of administrative reality for far too many people.
It really is.
Because, the collision between the sovereign power of the state and individual property rights is often where our most fundamental constitutional assumptions are tested.
Yeah, where the rubber meets the road.
Right. The state has this undeniable, historically recognized need to collect revenue. Without property taxes, local infrastructure just collapses.
Fire departments don't deploy, public schools close.
Exactly, the roads degrade. So the power to compel payment is immense. But when that immense power is aimed at a single citizen over a trivial or a disputed amount, the machinery can become incredibly destructive.
Completely blind to the collateral damage.
Completely. It just obliterates a family's life savings.
And that collision is really the center of our deep dive today. We are unpacking the source material surrounding a massive landmark Supreme Court decision that came down on June 23, 2026.
A huge case.
Yeah, the case is called Pung v. Isabella County. And to really get to the bottom of this, we have pulled together a stack of fascinating sources. We're looking at the actual Supreme Court slip opinion, the dense federal appellate records.
Very dense, yeah.
Very dense. Plus some truly shocking empirical amicus briefs submitted to the court, and a wealth of legal commentary from constitutional scholars and commercial real estate analysts.
We really ran the gamut on this one.
We did. The mission of this deep dive is to explore the razor-thin, incredibly consequential constitutional boundary between a local government's sovereign right to collect unpaid taxes and an individual's fundamental right to private property.
Right, specifically under the Fifth Amendment's takings clause.
Yes, and the Eighth Amendment's protection against excessive fines.
It's a huge legal showdown.
It really is. Okay, let's unpack this. Because before we can even begin to parse the Supreme Court's, high-minded ruling on the specific financial obligations of the government, we have to look at the human story.
We have to. The context is everything.
You have to understand the bizarre, almost unbelievable series of events that led a local Michigan county to seize a family estate in the first place.
Yeah, the origins of this dispute, they trace all the way back to 2004 when a man named Timothy Scott Pung passed away.
Okay, 2004.
Right. And he left behind a family property in Michigan. Under Michigan state law, this property held a principal residence exemption, or a PRE.
A PRE. So what exactly does that do?
So the policy rationale behind a PRE is actually quite sound. State legislatures generally want to encourage long-term home ownership and community stability.
That makes sense.
Right. They recognize that if you tax a primary residence at the exact same aggressive rate as, say, a commercial shopping mall or a lucrative vacation rental, you run the risk of taxing fixed-income residents out of their homes.
Like retirees, yeah.
Exactly, just to fund local projects or supplementary school operating budgets. So the PRE acts as this vital statutory shield. It exempts the primary home from those heavy supplementary local school operating taxes.
Okay, so the Pung estate had this exemption in place. Timothy passes away. The estate is being managed by the family, and everything is seemingly fine for years.
Yep, the property is shielded.
But then, enter Patricia DePriest. She is the local township tax assessor. And in 2010, so this is 6 years after Timothy Pung's death, DePriest decides to retroactively deny the PRE for the tax years of 2007, 2008, and 2009.
Retroactively?
Yeah.
Which is just wild.
I mean, you think your taxes are settled, you've balanced your books for the decade, and suddenly the township knocks on your door and says, actually, we reviewed our files, and you owe us for the last 3 years.
It's terrifying, and her reasoning for this was purely administrative.
Right, it wasn't like they suddenly turned it into a hotel.
No, not at all. She claimed that because the original owner died, a quote-unquote change in ownership occurred, which supposedly required the estate's administrator to file a brand new affidavit to maintain the exemption.
So just paperwork.
The bureaucratic logic there is incredibly rigid. She is treating the transition of the property into the estate as this trigger event that voids the existing protection.
Demanding fresh paperwork to reestablish a fact that hasn't actually changed in reality.
Exactly. The property is still the primary family asset. But, the Pung family didn't just passively accept this retroactive bill. They actively engaged the legal system to defend themselves.
And for them.
Yeah, they took the issue to the Michigan Tax Tribunal, which is a specialized administrative court designed to resolve these exact types of technical property tax disputes.
Okay.
And in 2012, the tribunal stepped in and ruled unequivocally in favor of the Pung estate.
Oh, wow. So they won.
They won. The judge explicitly overturned Dupree's decision, declaring that the principal residence exemption remained entirely valid for the estate, regardless of the missing fresh affidavit.
Okay, so the family wins. The state tax tribunal looks at the local assessor and says, you are wrong, the family is right, they don't owe these supplementary taxes.
Case closed. Right.
Right. At this point, any reasonable person would assume the matter is permanently closed. The state has spoken. But this is where the bureaucratic momentum becomes truly terrifying.
It really does.
Despite the binding ruling from the higher state tribunal, Patricia DePriest, the local assessor, defies it.
She just ignores it.
For the 2012 tax year, she revokes the exemption again, using the exact same unfiled affidavit rationale that the tribunal had just struck down as invalid. The audacity of that is just staggering.
It's unbelievable.
We actually have a direct quote from her from a subsequent hearing where she was asked about her refusal to follow the tribunal's ruling. She stated, on the record, "I don't care what he says, the law says that you do."
I mean, that single sentence encapsulates the danger of the administrative state operating without adequate oversight.
She just went rogue.
She did. She fundamentally believed her personal interpretation of the local tax code superseded the judgment of the state's own specialized tax court. She placed her authority above the tribunals.
And that single act of administrative defiance generated the entire disputed debt at the heart of this Supreme Court case. Right?
Yes, a tax liability of exactly $2,241.93. Because she placed that debt onto the official county ledger, she triggered this relentless automated collection process.
Right, because that $2,000 debt is now officially on the books. Isabella County Treasurer Stephen Pickens initiates what is called a non-judicial foreclosure.
And we really need to pause and explain what that mechanism actually is.
Yeah, because it is the engine of this entire tragedy. A non-judicial foreclosure means the county doesn't have to file a lawsuit against you.
They don't have to stand in front of a judge.
Nope. They don't have to prove that you owe the money, and you don't get a chance to stand in court and present the tribunal ruling proving that you don't. The county just executes the foreclosure administratively.
It's all behind the scenes. Local governments rely heavily on non-judicial foreclosures because of sheer volume.
Which, I mean, makes sense practically.
Sure. If a county had to initiate a full adversarial civil trial for every single delinquent property tax bill, the legal fees would bankrupt the municipality.
And the court system would just grind to a halt.
An absolute halt. So state legislatures grant counties this streamlined administrative power. It is designed for maximum speed and efficiency.
The flaw.
The fatal flaw, however, is that this automated machinery is entirely blind to ongoing legitimate legal disputes.
Right. The county's computer system doesn't know about Patricia DePriest's defiance.
It doesn't read the tax tribunal's previous rulings.
It only reads the ledger. It sees an unpaid balance of $2,241.93, and it initiates the countdown to seizure.
And to make matters worse, the procedural safeguards built into that automated system completely failed the Pung family.
Yeah, this part is crazy. Isabella County was legally required to notify the estate administrator, Michael Pung, or his legal counsel, that the foreclosure process had begun.
They have to give notice.
Right. Michigan law mandates a strict notice of redemption, warning the property owner that they have until March 31st to pay the debt or permanently lose the house. But our sources show that the Tinco County mailed this critical notice after the deadline had already expired.
After the deadline.
So the family is fighting the assessor, winning their case, and completely unaware that a different branch of the county government is simultaneously moving to liquidate their entire estate.
The timeline of the legal appeals overlapping with the foreclosure machinery is what makes this case so illustrative of systemic breakdown.
It's a train wreck.
It is. Let's look at February 2015. The Michigan Court of Appeals finally issues a definitive higher court ruling on the underlying tax dispute. They rule completely in favor of the Pungs.
Boom. Validation.
Right. They affirm, once and for all, that the family was legally entitled to the tax exemptions all along. The family technically owed nothing. The $2,000 debt was legally invalid from the moment DePriest fabricated.
It's a total legal exoneration. The Court of Appeals declares the Pungs innocent of the tax debt. But
there's always a but.
But by the time the appellate court published that ruling, Isabella County had already foreclosed on the residence and sold it at a public auction.
And the numbers involved in that transaction are just sickening.
They really are. The county itself had assessed the home at $194,400. That was their own internal valuation for property tax purposes.
Right, that's what they said it was worth.
But at their public auction, they sold the home for just $76,008.
Yeah.
The third-party investor who bought the home turned around and resold it on the open market about 18 months later for approximately $195,000.
Almost perfectly matching the county's original assessment.
Exactly.
So the family won the legal argument, but they lost the physical asset forever.
The judicial victory was entirely phantom because the administrative state had already liquidated the property.
And under the Michigan statutory framework that existed at the time of the sale, Isabella County didn't just sell the house to cover the $2,000.
No, they kept all of the proceeds. They kept the entire $76,008 bosses.
Which is just, it's hard to even wrap your head around.
It is. It's like getting your car impounded over a $10 parking ticket that you are actively fighting in traffic court.
Yeah, great analogy.
And while you are standing in front of the judge, and the judge is literally banging the gavel, declaring you completely innocent and ordering the ticket dismissed.
The tow yard down the street has already crushed your car into a cube.
Yes, and sold it for scrap metal to cover the impound fees. And when you show up with your court order, the city just shrugs and says, sorry, the system already processed the vehicle, and by the way, we are keeping the scrap money.
It violates every basic instinct we have about fairness and due process. The structural imbalance is severe.
It really is.
The government has the power to seize assets rapidly, but the citizens' ability to challenge the underlying basis for that seizure moves at the glacial pace of the appellate courts.
But thankfully, the legal landscape regarding those surplus funds had fundamentally shifted just before this case reached the Supreme Court.
Yes. The question that went to the Supreme Court in Pung v. Isabella County wasn't whether the county owed the Pung family money. The question was entirely about the baseline for calculating that debt. How much money did they owe them?
Right. And to understand how the Supreme Court approached that calculation, we need to establish the constitutional baseline that existed right before Pung.
Right, the setup.
In 2023, there's a massive earthquake in property law called Tyler v. Hennepin County.
A huge case.
The Supreme Court definitively established in Tyler that when a government seizes a home for back taxes, sells it, and keeps the surplus proceeds above what was actually owed, that constitutes a violation of the Takings Clause of the Fifth Amendment.
A government cannot steal your equity to pad its own municipal budget.
Exactly. So because of the Tyler precedent, Isabella County knew they couldn't just keep the $76,000. They owed the Pung estate the surplus. But Tyler left a massive, multi-million-dollar ambiguity in the law.
It declared that the government must provide just compensation, but it completely failed to define what the baseline for that compensation should be.
Right. The justices in Tyler answered the if, but ignored the how much.
And that is exactly the vacuum the Pung case was meant to fill. The Supreme Court was presented with three radically different arguments for how to measure justice and value when the state takes a home.
Okay, let's break those down. First up, we have the petitioner's argument.
Right. Michael Pung, represented by his counsel Philip L. Ellison, he anchored his argument in the concept of fair market value, or FMV.
FMV.
Ellison argued that just compensation under the Fifth Amendment must be measured by what the property was actually worth in the real world at the time it was taken.
And Ellison's argument points out the sheer, undeniable hypocrisy of the county's math here.
Oh, yeah.
Isabella County itself assessed the home at $194,400. They used that exact number to calculate the Pung's tax burden for years. Therefore, Ellison argued, the Cal County owes the family that full $194,400 minus the $2,242 debt.
The government should be writing the Pung estate a check for roughly $192,158.
Because Ellison framed the $76,000 auction as a rigged fire sale that artificially depressed the price.
Right, arguing that the family shouldn't have to suffer a massive financial penalty just because the government uses bad auction mechanics to liquidate assets.
From a layman's perspective, I mean, the fair market value argument feels intrinsically correct.
It does. If the state takes an asset worth $200,000, the state should compensate the owner $200,000.
But then we have the respondent.
Right, Isabella County, represented by counsel Matthew T. Nelson. And he offered a fierce defense grounded in centuries of Anglo-American legal tradition. Nelson argued that the return of the actual surplus proceeds from the public auction fully satisfies the constitutional requirement of just compensation. In the county's view, the baseline isn't some hypothetical real estate appraisal.
It's the actual cash generated on the courthouse steps.
Exactly.
So the county's math is brutally simple. The auction yielded $76,008. You subtract the $2,242 old debt, and the county owes the family exactly $73,766.
Right. And they argued that forcing local governments to guarantee fair market value appraisals would make tax sales financially impossible,
Plunging every routine municipal debt collection into endless constitutional litigation over competing real estate appraisals.
Exactly. So we have the idealist argument of true value on one side and the pragmatist argument of actual cash on hand on the other.
And then, stepping right into the middle of this crossfire, we have the amicus curiae brief for the United States government, represented by Frederick Liu.
Yeah, the federal government took a highly strategic middle ground here. They refused to explicitly support the Pung family's demand for fair market value, nor did they fully endorse Isabella County's actions.
So what did they do?
Instead, Frederick Liu issued a stark, apocalyptic fiscal warning to the Supreme Court. He argued that if the court adopted a strict fair market value rule, it would impose catastrophic financial shortfalls on local governments nationwide.
Because municipalities would be forced to pay out millions of dollars
Yep.
in hypothetical real estate equity that they never actually collected in cash.
Right. He warned that this massive unfunded liability would inevitably be shifted onto everyday law-abiding taxpayers in the form of massive tax hikes just to cover the legal payouts to delinquent property owners.
Wow, so the underlying tension of the Fifth Amendment is really on full display here.
It is. The text of the amendment is incredibly sparse. It simply says, "Nor shall private property be taken for public use without just compensation."
It offers zero mathematical formulas.
None. It doesn't define just, and it doesn't define compensation. The justices had to grapple with a fundamental philosophical dichotomy.
Does just compensation mean what the property is worth? In a perfect, frictionless world where you have 6 months to market a home with a professional realtor, stage the interior, and wait for the perfect buyer?
Right, the dream scenario.
Or does it mean what the property actually fetches on the courthouse steps on a rainy Tuesday morning when the government forces a rapid, involuntary liquidation?
Exactly.
But wait, if the government violated the Constitution by taking the property in the first place, which Tyler established they do when they keep the equity, why shouldn't the penalty be tied to the true value of what they effectively stole?
That's the core question.
I mean, if I steal your Rolex and sell it to a guy in an alley for $50, a judge doesn't say, I only owe you $50.
No, of course not.
The judge says, I owe you the actual market value of the Rolex. I don't get to use my terrible fencing skills to lower my liability. So why does the government get to use a discount price to measure their constitutional violation?
It's a great question. And while that analogy perfectly captures the frustration of the individual property owner, constitutional law dealing with sovereign powers rarely operates on the principles of pure individual fairness.
Really?
Yeah, it operates on deep historical precedent and the macro-systemic needs of the state to function. The Supreme Court is not just looking at the Pung family. They are looking at the entire mechanism of municipal finance in the United States.
The big picture.
And that systemic macro-level view is exactly what dominated the Supreme Court's thinking.
Right, because the Supreme Court answered this question with a resounding 9-0 judgment, prioritizing historical tradition and pragmatic reality over hypothetical real estate appraisals.
Unanimous. 9-0.
Yeah, the majority opinion was authored by Justice Samuel Alito, and it completely reshapes how we understand property rights in America.
Yeah.
I mean, when you have an ideological spectrum that broad.
Oh, yeah. Alito joined in full by Chief Justice Roberts and Justices Sotomayor, Kagan, Gorsuch, Kavanaugh, Barrett, and Jackson.
Agreeing on a contentious property rights issue. You know, they are anchoring their reasoning to something very deep in the legal bedrock.
Absolutely. Justice Alito anchors his entire argument on a crucial foundational distinction. He draws a massive, thick red line between traditional eminent domain and tax foreclosure liquidations.
Okay, let's break down that difference.
So in a traditional eminent domain case, the government decides it needs to build a new highway, a public school, or a military base. They initiate an involuntary acquisition of your property for public use.
You, the owner, have done absolutely nothing wrong.
Right. You are completely blameless. Your land just happens to be in the way of progress. Because you are an innocent party being forced to sacrifice your property for the public good, the Constitution demands that the baseline for just compensation is the fair market value.
The government must make you entirely financially whole.
Exactly. The eminent domain scenario is the perfect world valuation. The state has to act like a willing buyer.
But Alito says a tax sale is fundamentally, historically different from eminent domain.
He traces the history of seizing real property to satisfy unpaid taxes all the way back to the Magna Carta and the founding-era statutes of the United States.
The Magna Carta, going way back.
Way back. He notes that historically, a tax sale has never been treated like eminent domain. In a forced liquidation to collect a delinquent debt, historical tradition consistently treats the actual sale price obtained at a public auction as conclusive evidence of the property's value.
Interesting.
Historically, the sovereign's only obligation was to return the overplus, the literal cash difference between the final bid and the tax debt. The sovereign was never expected to act as a guarantor of the property's maximum potential value.
And this historical analysis brings us to perhaps the most provocative part of Alito's opinion, the concept of taxpayer agency.
Yes, this is huge.
Alito essentially argues that unlike eminent domain, where a government bulldozer just shows up unannounced, a delinquent taxpayer has choices. They have a say in their destiny. The court points out that the Pungs had years to resolve this delinquency before the auction hammer fell.
And the concept of agency is a critical pillar of the majority's reasoning here. Alito lists the remedial avenues the family possessed. He argues they could have paid the disputed $2,000 tax under protest, securing the property while continuing to fight the assessor in the tribunal.
Or they could have refinanced the property to cover the debt.
Right. Or, crucially, they could have voluntarily sold the house themselves on the open market, realized the full $194,000 fair market value, paid off the $2,000 to the county, and kept the rest of the equity.
So the court reasons that because the taxpayer had the agency to prevent the forced sale entirely, the state is not constitutionally obligated to guarantee a premium price when the taxpayer's inaction finally forces the state to act.
Exactly. The state is acting as a debt collector of last resort, not as a bespoke real estate agency.
And the court is also looking at the sheer mechanics of running a city. This brings us to the doctrine of pragmatic solvency. Alito observes that public auctions are designed for one specific purpose: rapid, efficient debt collection without massive administrative overhead. If the court had adopted the Pung family's fair market value theory, local governments would essentially be forced to guarantee market outcomes.
Municipalities would have to become real estate brokers.
Right.
And the logistical nightmare of that requirement would be insurmountable. Cities would have to hire professional appraisers for every single foreclosed property. They would have to pay to maintain the properties, landscape them, repair the roofs, and moisten them for months to fetch retail prices.
Which they just don't have the budget for.
Not at all. And if they failed to achieve that hypothetical appraised value at sale, they would face endless constitutional litigation from former owners demanding the difference.
Wow.
The court realized that imposing a fair market value mandate would completely collapse the entire system of local taxation. Tax sales would become financially perilous, and counties would simply stop collecting delinquent taxes, leading to municipal insolvency.
To bolster this pragmatic view, the court draws a really interesting analogy to bankruptcy law. They cite a 1994 case called BFPV Resolution Trust Corp.
The connection here is fascinating. In the BFP case, the Supreme Court had to decide what constitutes reasonably equivalent value when a foreclosed property is sold during bankruptcy proceedings.
Right.
In that 1990s bankruptcy case, the court explicitly rejected the idea of using hypothetical open market valuations in forced sale contexts. They held that as long as a non-collusive mortgage foreclosure sale is properly conducted according to state law, the price it fetches is, by definition, the reasonably equivalent value.
The forced sale price is the reality.
Exactly. And in Pung, Alito extends that exact logic from bankruptcy law directly into the constitutional takings clause. He states that if the tax auction is fairly conducted in light of our country's history, the auction price is the constitutional baseline. It is the definitive measure of value, superseding any theoretical appraisals.
And to close the loop on the petitioner's arguments, the majority outright rejected Pung's secondary claim under the Eighth Amendment, right?
They did.
Pung argued that losing over $100,000 in equity to satisfy a $2,000 debt was so disproportionate that it constituted an excessive fine.
But the court acknowledged that a forfeiture of property can be a fine if it is explicitly meant as a punishment.
Right.
But Alito concluded that Pung failed to show any historical evidence that a fairly conducted surplus returning tax sale was ever considered a punishment by the founders. It is strictly a mechanism of debt recovery.
Because it isn't a punishment, the Eighth Amendment doesn't force the government to pay out hypothetical market values either.
Right. The overarching theme of pragmatic governance dominates the majority opinion. The court is prioritizing the survival of the municipal framework over the maximization of individual equity in a delinquency scenario. They recognize that debt collection requires blunt instruments.
But, the reliance on taxpayer agency is deeply troubling when you apply it to the actual facts of the Pung case.
It really is.
Alito leans heavily on the idea that the Pungs had choices, that they could have sold the house or paid under protest. But how can you have true agency to stop a foreclosure when the county literally failed to notify the estate administrator until the legal deadline to act had already passed?
Exactly.
Is agency just a theoretical, philosophical concept of the Supreme Court, completely detached from the physical reality of a late postmark on a government envelope? If you don't know the machinery is moving, you can't exercise agency to stop it.
And that exact friction point makes this decision highly controversial among legal scholars. The court relies on a presumption of procedural functionality. They assume the taxpayer knows about the debt, receives timely notice, and simply fails to act out of negligence.
But when the bureaucracy itself breaks down, when notice is mailed late, when an assessor goes rogue and defies a tribunal, that theoretical agency becomes a complete illusion. The citizen is trapped.
And that illusion isn't just a one-off mistake in Isabella County. The Supreme Court saw extensive evidence proving that this system is structurally broken all over the country. The court ruled that the auction price is an acceptable baseline theoretically, assuming the auction is a functional market. But amicus briefs presented to the court showed that, in the real world, these tax options are far, far from functional, fair markets. They are practically designed to fail the homeowner.
Okay, let's dive into that. Because the empirical evidence submitted to the court by organizations like Maryland Legal Aid and Mountain State Justice pulls back the curtain on a deeply unsettling reality.
It's eye-opening.
These briefs make a vital comparison between normal mortgage foreclosures and tax sale foreclosures. The mechanics matter immensely here.
They do. When a bank forecloses on your mortgage, the bank actually wants the property to sell for as high a price as possible. The bank usually has a massive outstanding loan balance to cover, say, $300,000.
Right, they want to recoup their losses.
Exactly. So the bank has a direct financial incentive to market the property, advertise the auction, and drive the bidding up to cover their massive loss. In a standard mortgage foreclosure, properties typically sell at a discount of about 20% to 25% off their actual market value. It's a forced sale, so there is a discount, but it's tethered to reality.
Tax sales, however, are explicitly structured as what the amicus briefs call fire sales.
Right.
The municipality doesn't care about maximizing the price. The municipality only cares about covering the $2,000 tax debt. Once the bidding hits $2,000, the government's incentive to market the property drops to zero.
Exactly. The empirical data points provided to prove this structural depression of value are horrifying. Let's start with the Pung case itself in Michigan. The assessed value was $194,400. The sale price was $76,008.
That means it sold for 39.1% of its market value.
And within the context of the data submitted to the court, the Pung family's outcome was actually one of the better ones.
Which is crazy to think about.
I know.
The brief highlights a case in Maryland involving the Edmondson organization. The assessed market value of the property was $140,000. The original tax debt was just $2,543. The property sold at the public tax auction for $5,115.
That is an astonishing 3.6% of its actual market value.
A $140,000 home sold for $5,000. How is that mechanically possible in a room full of rational human beings? Why wouldn't someone bid $20,000 or $50,000 to get a massive bargain?
We need to understand how the tax lien investment industry actually operates to answer that, and we have more examples that illustrate the trend.
Hit me.
In West Virginia, the Anthony Wright property had an assessed value of $65,000. The tax debt was a microscopic $79.89. The winning auction bid was $2,700. It sold for 4.1% of its value.
Wow.
In Nebraska, the Kevin Fair property had an assessed market value of $59,000 with a tax debt of $588.21.
Oh my God.
That is exactly 1.0% of the market value.
So what are the actual mechanics of these tax lien syndicates? How do they suppress the bids so severely?
The legal system, as articulated by the majority opinion, assumes an auction naturally finds the market price. But these empirical studies, including a comprehensive study of Washington, D.C.'s tax lien auctions, reveal that these structures are explicitly designed not to attract real home buyers.
How so?
First, the auctions often require all cash payments immediately upon winning. A normal family cannot secure a traditional mortgage for a tax sale property.
Right. Who has that kind of cash on hand?
Second, there are no interior inspections allowed. You are buying the property completely blind, assuming massive risk regarding the internal condition.
It could be gutted inside.
Exactly. Third, the titles are often clouded, meaning you cannot get title insurance immediately, which further repels traditional buyers.
So there is zero marketing to the general public. The barriers to entry are incredibly high, and the risk profile is massive.
Yes. Because normal buyers are locked out by these mechanics, the only people in the room are sophisticated, heavily capitalized third-party investment syndicates. These syndicates understand that if they don't bid against each other, they can acquire portfolios of properties for pennies on the dollar. The auction environment becomes highly insular, often resulting in bids that barely clear the nominal tax debt.
It's an insider's game. It's an environment engineered to prevent price discovery.
Totally.
And the consequence of that absurdity is a massive systemic wealth transfer. Without judicial safeguards, these municipal tax sales result in uncompensated wealth transfers from vulnerable homeowners, often the elderly, the poor, or those trapped in bureaucratic errors like the Pungs, directly to sophisticated third-party investors and local governments.
The Supreme Court saw this exact data. They were fully aware of the 1% to 3% fire sales occurring nationwide. And yet, the majority still ruled that fair market value isn't constitutionally required. They accepted the auction price as the baseline.
But a specific block of justices saw this empirical data and decided to leave a massive, blinking escape hatch for future homeowners to fight back against these predatory mechanics.
Yes, this is where the legal maneuvering becomes incredibly sophisticated. Let's look at Justice Sonia Sotomayor's concurring opinion. She was joined by Justices Gorsuch and Jackson.
It is a really interesting ideological alliance. Sotomayor and Jackson from the liberal wing, joining with Gorsuch, a staunch originalist.
Very interesting. Sotomayor's concurrence is very brief, but it is surgically precise.
Okay, what does she say?
She highlights a specific, highly consequential phrase that Justice Alito used in the majority opinion. Alito wrote that the actual auction price is the baseline, assuming the auction is fairly conducted in light of our country's history of tax sales.
Fairly conducted. Those two words are doing a massive amount of heavy lifting.
They are carrying the weight of the entire future of property rights litigation. Sotomayor points out that the court, while rejecting the demand for hypothetical fair market value, absolutely did not define what makes an auction fairly conducted. The majority opinion left the contours of a fair auction completely blank. Furthermore, her concurrence explicitly notes that the Supreme Court was not endorsing Isabella County's specific procedures as fair.
So they left the adequacy of Isabella County's auction completely open for the Sixth Circuit Court of Appeals to evaluate on remand.
Exactly.
She essentially highlights a giant loophole and hands it directly to future plaintiffs.
It's more than a loophole. It is an entirely new legal battleground. The strategic genius of this concurrence is that Sotomayor is shifting the entire focus of property rights litigation moving forward.
Pre-Pung, every lawyer in America representing a foreclosed homeowner was fighting over real estate appraisals.
Right. They were arguing over how much the house was worth in theory, bringing in competing experts to debate property values. Post-Pung, thanks to Sotomayor's fairness proviso, that entire strategy is dead. Instead, lawyers are going to relentlessly attack the structural integrity of the auctions themselves.
They're going to audit the machinery.
Yeah.
They're going to ask, did the county advertise the sale properly? Or did they just post a tiny notice on a bulletin board in the basement of the courthouse? Were the bidding increments designed to encourage competition, or were they structured to suppress it?
Did the all-cash requirement artificially suppress the buyer pool?
Right. And in the Pung specific case, was the notice of redemption adequate given it was provably mailed late?
Exactly. If a plaintiff can prove the auction mechanics were structurally unfair or deviated from historical norms, they can argue the resulting price is constitutionally invalid, even under Alito's pragmatic framework.
Now, while Sotomayor focused heavily on procedural fairness going forward, defining the rules for future auctions, Justice Clarence Thomas took a completely different approach.
Fresh looked backward.
He dove deeply into the very history that Alito relied upon to justify the pragmatic outcome, and Thomas concluded that Isabella County had already violated centuries of legal tradition.
Justice Thomas's concurrence is a masterclass in originalist jurisprudence. It is a massive, sprawling opinion, joined mostly by Justice Gorsuch.
Thomas grounds his entire argument in constitutional first principles and natural rights. He even cites his own famous dissent in Kelo v. New London, a massive eminent domain case about seizing private homes for corporate development, to reiterate his enduring belief that the primary purpose of government is to protect private property, not to expropriate it for municipal windfalls.
And he cites Sir William Blackstone, the legendary English jurist whose writings deeply influenced the Founding Fathers, to establish the sacred nature of real estate.
Thomas has a fundamentally different view of the state's role than Alito does.
He really does. While Alito sees the state as a necessary debt collector needing efficient tools to survive, Thomas sees a sovereign entity inherently prone to abusive overreach that must be strictly restrained by historical precedent.
Thomas points out the glaring hypocrisy of Isabella County's mathematical position.
He notes the duplicity of assessing the home at $194,000 when calculating how much tax the citizen owes the state, but fiercely defending a $76,000 auction price when calculating how much compensation the state owes the citizen.
Which, is a very fair point.
Oh, absolutely. But Thomas goes much further than just calling out hypocrisy. He dives into the specific historical practices of tax collection that the majority leans on.
Right.
And he argues that while history does indeed allow for forced sales, that same history also imposed strict, unyielding procedural limitations on the state limitations that modern municipalities like Isabella County completely ignore.
He outlines two specific historical violations. Let's go through them. The first one he calls the exhaustion of personality.
Right. Personality refers to personal property, movable assets that are not real estate. Historically, under the exact common law traditions the court claims to be upholding, tax collectors could not just jump straight to seizing your house.
They were legally required to first seize and sell a delinquent taxpayer's movable personal property to satisfy the debt.
They had to take your cattle, your carriage, your furniture, your personal goods. They had to auction those items off first.
Real estate was considered so fundamental to a citizen's standing and survival that seizing the land was the absolute last resort, permitted only when all personal property was exhausted.
And in this case, Thomas points out that Isabella County bypassed all of those historical prerequisites. For a trivial $2,242 debt, they immediately targeted the Pung's physical residence, their most valuable foundational asset.
Without ever attempting to satisfy the debt through less intrusive means, like garnishing bank accounts or seizing vehicles.
They skipped straight to the nuclear option.
And that leads to his second historical point, the rule of parceling, or divisibility.
This is another crucial historical safeguard designed to prevent the exact kind of disproportionate wealth transfer we see in modern tax sales. Traditional tax foreclosure laws dictated that the state could only seize and sell as much of a debtor's land as was strictly necessary to satisfy the delinquency.
Think of it like owing a debt to the local baker. If you owe the baker for a loaf of bread, the magistrate might allow the baker to take a slice of your pie to settle the account. But the magistrate would never allow the baker to legally confiscate your entire bakery, sell all your ovens, and keep the surplus just because you owed for one loaf. It violates any basic sense of proportionality.
Yet, that is exactly what the state does with real estate. Historically, seizing and selling an entire undivided parcel especially a complete residence, to satisfy a tiny debt when the property could theoretically be divided or partially encumbered, was viewed as legally void.
Thomas concludes his deep historical dive with a direct, powerful condemnation. He writes, "What Isabella County did to the Pungs was wrong, and, on my initial view, likely unconstitutional."
By stating this so clearly, he is teeing up the Pung family and countless other plaintiffs to continue their fight in the lower courts.
Armed with massive originalist ammunition regarding the exhaustion of personality and the rule of parceling.
Now, before we move on to the massive systemic impacts of this ruling, we have to talk about the judicial alignment here because the sources highlight a truly bizarre quirk involving Justice Neil Gorsuch.
Yes, the Gorsuch footnote quirk. It is a perfect illustration of how granular and complex originalist jurisprudence can get at the Supreme Court level.
It requires a bit of a roadmap to unpack. So Justice Alito writes the main opinion for the court. Justice Gorsuch joins Alito's opinion in full.
Okay.
That includes Part IIB of Alito's opinion, which explicitly rejects the Pung's claim that losing their equity violated the Eighth Amendment's excessive fines clause. Gorsuch agrees with Alito. The loss of equity is not an excessive fine because a tax sale isn't a punishment.
But at the exact same time, Gorsuch also joins Justice Thomas's massive historical concurrence, where Thomas argues the county likely violated the Constitution by ignoring historical limitations like parceling.
Right. However, because Thomas personally believes the taking of the equity might actually violate the Eighth Amendment, Thomas refused to join Part IIB of Alito's opinion.
So Thomas writes footnote 1 in his concurrence, specifically to explain why he, Clarence Thomas, is refusing to join Alito on the Eighth Amendment issue.
But because Gorsuch did join Alito on the Eighth Amendment issue, Gorsuch has to formally, explicitly exclude himself from Thomas's footnote 1.
So the official Supreme Court record shows that Gorsuch joined Alito in full and joined Thomas's concurrence, except for footnote 1.
It is the most hyper-specific, legalistic hair-splitting imaginable.
It really is. So why is this level of bureaucratic maneuvering important for you, the listener, to understand?
It reveals something profound about the internal dynamics of the court. It shows that the originalist wing of the court is deeply conflicted about how to handle abusive municipal tax collection.
They agree that historical practice allows forced sales, but they vehemently disagree on what constitutional guardrails remain when modern municipalities act like predatory hedge funds.
Thomas is sending a clear message. If municipalities want to wield the historical protection of forced sales to avoid paying market value, they have to accept the historical limitations like exhausting personal property and parceling land too.
You cannot cherry-pick history to maximize municipal revenue while ignoring the historical protections afforded to the citizen.
Exactly.
Now, this massive 9-deal Supreme Court decision doesn't just affect the Pung family or people who forget to pay their taxes. It sends a massive shockwave through the broader commercial and legal world.
Let's look at the systemic ripples, starting with the post-Tyler realignment.
Okay.
Before Pung, after the Tyler decision came down in 2023, property rights advocates were euphoric. They believed Tyler was the beginning of the end for tax foreclosures as we know them.
They hoped the logical extension of Tyler meant that full fair market value compensation was going to be mandated across the board.
They thought the gravy train for tax lien investors was permanently derailed. But Pung serves as a hard boundary on that momentum. It clarifies the scope of Tyler.
Pung says, no, the state cannot keep a surplus windfall, but the state is not required to insulate you from the financial friction of a forced liquidation.
The property interest protected by the Constitution is bounded by the mechanical reality of the public auction. The state owes you the surplus cash, not the theoretical equity.
And as we discussed with Sotomayor's concurrence, the entire focus of municipal litigation pivots away from fighting over competing real estate appraisals, and it pivots toward auditing the auction procedures.
City planners across the country are reading this decision and realizing they must urgently review their entire foreclosure playbook.
How are they providing notice? What are the bidding increments? How long is the redemption window?
If a town is still running obscure, cash-only auctions on the courthouse steps with no marketing, they are walking into a constitutional buzzsaw under the Sotomayor framework.
Beyond municipal planners, the impacts on commercial law and bankruptcy law are immense. We mentioned the BFP case earlier.
Pung provides bankruptcy attorneys with immense persuasive constitutional authority. In bankruptcy law, particularly Chapter 7 liquidations, trustees and courts are constantly having to calculate the hypothetical value of a debtor's estate to figure out how to distribute assets to creditors.
Pung strongly cements the idea that Forced sale liquidation value is an entirely separate, legally valid baseline, distinct from retail market value.
It tells bankruptcy courts that actual auction value is a constitutionally sound metric for determining the worth of an estate in distress.
And by validating the discount, the Supreme Court is providing massive market stability to the financial sector.
The tax lien investment industry is a multi-billion-dollar sector. More importantly, municipal bond markets rely heavily on the predictable, efficient collection of delinquent taxes.
If Pung had gone the other way, and retroactive fair market value lawsuits were permitted, it would have crashed the municipal bond market.
Cities would have faced billions in unfunded liabilities for past auctions. Pung preserves the stability of local government debt collection by ensuring that past, fairly conducted auctions cannot be retroactively challenged based on hypothetical appraisals.
It perfectly illustrates how constitutional law is rarely a simple command. A single unanimous decision fractures into multiple directives depending on who is reading it.
A city planner sees a warning about procedural fairness. A bankruptcy attorney sees validation of liquidation pricing.
Wall Street debt buyers see crucial market stability. And property rights advocates see a roadmap from Justice Thomas to attack the historical basis of modern foreclosures.
It is a recalibration of a massive, interconnected system.
We started with a local assessor's stubborn refusal to accept a tribunal's ruling, and we ended up with a definitive Supreme Court ruling that reshaped the boundaries of American property rights.
Quite the journey.
But before we wrap up, there is one final, provocative thought that emerges from all these sources, something we haven't explicitly discussed yet.
This is the dark question.
It is. If the Supreme Court just ruled that the government only owes the actual auction price, and if Justice Sotomayor's fairness proviso only really requires basic, traditional procedural steps like adequate mail notice in a public venue.
What stops a local municipality from intentionally gaming the system entirely?
Exactly. What stops a town that wants to acquire a specific parcel of land for cheap public development, or maybe to sell to a favored developer, from designing legally adequate but highly obscure auctions?
They now have a direct financial incentive to ensure that the bidding at the tax auction stays as close to the initial tax debt as possible.
As long as they check the procedural boxes, mailing the notice on time, publishing a small ad in a local paper, they can legally seize a $200,000 property for pennies. They can claim they technically satisfied the Constitution by returning the $50 surplus.
Where does the law protect the citizen when the government itself stops being a neutral debt collector and becomes an opportunistic investor?
If the baseline of justice is whatever the auction yields, and the government controls the auction mechanics, the vulnerability of the property owner is absolute.
It really is.
The illusion of absolute ownership we talked about at the very beginning, that comforting feeling of holding a paid-off deed, really is just an illusion. You own it right up until the bureaucracy decides it's time for a rainy Tuesday fire sale.
Well said.
Thank you all for joining us on this deep dive into the source material. It's been an incredible journey unpacking this with you. Keep questioning the systems around you, and we will catch you on the next deep dive.